COVID-19 pandemic, and in accordance with House Rule 67 and the Governor's Emergency Order Number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. Please note that there is no physical location for the members of the public to observe and listen contemporaneously to this meeting. However, in accordance with emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform, and the public has access to contemporaneously listen, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar through the electronic calendar on the General Court website. The notice for this meeting complies with House rules and RSA 91A. Anyone who has a problem accessing this meeting should call 603-271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. Please note that all votes that are taken during this meeting shall be done by roll call vote. I'm going to start the meeting by calling the roll as soon as I throw my dogs out. Okay, so Representative Lekis.
I'm at home. My wife's around. Actually, she's on an education meeting in another room.
Okay, excellent. Representative Groda.
I'm here in my home office alone.
Representative Lanzara.
Hi, home in Nashua. I do have some workers that may be in and out throughout the day.
At least they're not barking. Representative Schultz.
I am transitioning to my computer in Concord at home shortly, and my husband will be in and out of the room.
Okay, very good. I hope you feel well, Representative Schultz. You sound a little under the weather.
Oh, I'm fine. Thank you. I think it's just allergies.
Okay. All right, so where we left off, we had pretty much agreement on what we wanted to see changed in this. Why don't we start off with everybody's piece that they had changed? Representative Lekis, are you prepared to tell us what you got changed? I know it was all circulated by Ms. Marlin.
Right. So there were two aspects. One is every place it mentioned, this is for context, this was grandfathering in summer camps that have been grandfathered, but there was the condition that it only worked if they operated continuously. And some of them were not able to operate last summer due to COVID. And I was concerned that at least some of them might either not operate or not be able to operate at full capacity this year. Hopefully that won't happen, but we'll see. And so any place that had the summer of 2020, and I changed the summers of 2020 and or 2021. And then we discussed having it sunset at the end of this year. And my only concern is I don't know, and I put that in the email, I'm not sure how things are interpreted as far as the law goes. I put some language in there to cause it to sunset the end of this year. But if the law goes away, are they still grandfathered in? If let's say they weren't operating last summer, the way the language works, it's clear that, they could operate this summer, they'd still be grandfathered in. But my concern was if the language, if it expires at the end of this year, they're going to have a problem next year. And I think it would make sense that they wouldn't, but I don't know how that works. And I'm wondering if there's a lawyer in OLS who could, could give an answer to that. So what I'd like the amendment, the amendment has the language to cause it to sunset. And Ms. Marlin, if when you put the thing together, if you could ask them about that, and if there's any doubt about whether they would still be grandfathered going forward if it expired, then just leave that section out, please.
Could you send me a copy of what you've got?
I sent it to the committee email address. Doesn't that go to you as well or not?
No, it does not.
Oh, I apologize. I'll do that.
Okay.
But that's all there is to it.
I have a question, please. Ms. Marlin, could you send me the link to this again so that I can, raise my hand effectively as the conversation goes?
Sure.
Thank you.
Mr. Chairman, I don't know whether you can see me.
Oh, I'm
on
sorry,
your screen.
I was muted. Just a second, I can't see you, Representative Schultz. Schmidt, I mean. Representative Lekis, is your concern that with the sunset provision that the camps that are able to operate this year and last year would then not be able to operate the following year once the statute goes away because they were not operating last year? Is that what
Right. I mean, my concern is, let's say they were not able to operate last year due to COVID. And let's say, COVID's not a problem this year. So, clearly they'd be able to operate this summer. But with the statute ending at the end of this year, expiring at the end of this year, would they have a problem next year and the years going forward? And I just don't know, what happens, how that's interpreted, by courts. And Ms. Marlin, I just sent you a copy.
Okay, if we can get an opinion, I think it
Thanks.
would, because to say otherwise would be just because the law expired, it was the law at the time. So, but it's
Yeah. It's an issue of looking at what their situation is going forward after the law's expired. I think it kind of makes logical sense that they'd be okay. But sometimes I know the way things are interpreted does not necessarily go along with common sense logic. So that was my concern.
That's crazy talk,
believe
Representative Lekis.
Sorry, I believe Representative Lekis that if you sunset a statute, then the previous statute that applied takes over.
Right, but okay.
Yeah, but he's concerned that retroactively they would look back and see that they didn't operate since the statute that allowed them to continue grandfather because they couldn't operate would then affect them. But I think just a quick opinion from all of us won't kill us to get the confusion out of it.
Right.
Representative Schmidt.
Why would they have not, what would be a reason for them not opening if they could?
Oh, no.
Well, only if they couldn't.
My concern is this, is let's say they could not open last year because of COVID. And the amendment here would let them open. The issue is the previous law was that they could continue their non-conforming use as long as they operated every year.
I see.
Right. And so if the statute expires, then there was a year when they were not operating. And so maybe the interpretation could be next year and all future years, they couldn't operate. I mean, that'd be kind of illogical, but technically that might be the way it would work.
You could write in the amendment that this, you can write something in the amendment that says that failure to open due to COVID is not a reason to, you can refer to that statute and say that failure to not open would not account for, not being open a year based on an unconventional use.
Yeah, I mean, if you just get rid of the
expires, if it expires, that doesn't mean anything either, except for it would give legislative intent.
Right. So, I mean, the easiest thing might be not to have it expired. The only reason I wanted to have it expired is, years from now, we still have this thing in the RSAs that, was an artifact of COVID, but it might actually be necessary to leave it in. That was my concern.
Well, we'll see from OLS. Okay, Representative Schmidt.
Well, you've been kind of massaging the issue I wanted to address, Mr. Chairman, but clearly the pandemic is an extraordinary circumstance that you want to factor in, and that's what you're trying to do, Representative Lekis. But I think the language has to reflect that it's only the extraordinary circumstance that takes away the previous stipulation that they had to be effectively in continuous operation. and to the degree that they would not open for other reasons, let's say somebody died, ownership transferred, they had financial difficulties, whatever, that would not fall under the rubric of the pandemic at all. that you have to, that now you're trying to figure out how you want to handle it. And so I just think that the language has to reflect the extraordinary circumstance aspect and nothing else. Because otherwise you're going to say, or if this, or this, or this, now you're setting up all kinds of additional terms and conditions. So.
The language clearly deals only with COVID. I mean, it's
Right.
very clear.
But running it past an attorney is the appropriate thing to do. That's why they study law, because they need to be able to put things in language that meets the legal requirements. And you can see we are struggling with that aspect.
Right, I agree. That's what I asked for Ms. Marlin when she put the
Exactly. So
the
I
composite
see where you're going, and running it past the attorney is the right thing to do.
Okay.
Okay, let's move along. I don't want to get tied up on this piece of it. Representative Brewer, please, what do you have to tell us about the portion you had done?
Are you speaking? I'm sorry. Did you hear? Did you say Representative Grota?
I did, yes.
Okay. Yes. So I had outdoor dining, and I got input from both Darren, from everyone actually. Darren Wyndham, Margaret Burns, and Rob Tardif. And the document that I put together was circulated to the group. I think we have something that's easier to say. First of all, the amendment, the part of the amendment in red, it says, so let me read it. Restaurants and other food service establishments licensed under RSA 143-A:4 shall be permitted to expand outside whenever an outdoor dining area can be set up safely, such as parking space close to the entrances, sidewalks, existing patios, lawn areas, or other appropriate areas, provided that. And then there was this issue about municipal wastewater systems, whether it be a septic tank or a sewer. So the original language that was sent to me by DES said that if the restaurants or food establishment is served by a waste disposal system as defined by RSA, no additional seating shall be allowed without first obtaining approval from DES. I'd like to take that out and say, for establishments that are on municipal sewer, they can expand seating as the municipality allows, because the sewers are municipal.
Yeah.
So if that's okay with everyone, this sentence would read, or other appropriate areas, provided that for establishments that are on municipal sewer, they can expand seating as the municipality allows. And then New Hampshire Municipal Association added the sentence, outdoor dining expansions are subject to all other applicable local regulations and ordinances.
Very good.
So that clarifies the wishy-washy, well, let's not call it that, the unclear reference to local rule.
Yeah.
And so, and then the rest of it stays the same. So what I can do is, if everyone agrees, I can send to you all that new condensed version.
Yeah, send it to Ms. Marlin too, please, because she's going to wrap all this together into one amendment.
Okay.
Did anyone else besides me have anything that they were getting? I guess not. So let me find the changes I did.
Representative Roy, Representative Allegro seems to have his hand up.
Oh, thank you. I appreciate that. Hold on a second. Go ahead, Representative Allegro.
Thank you. I'm not sure if this is the right time in the scheme of things, but it was brought to my attention today, and this is hard for me to keep track of, so I hope I'm not referring to something that has already been fixed. But on page 3, lines 16 to 20, there's a section that begins with current and former military service members, military occupation specialty code. It has one for the Army, it has one for the Air Force, but it was brought to my attention that there's nothing for Navy corpsmen. Is that an oversight?
Quite possibly.
Page 3, lines 16 to 20.
I just want to say to Representative Allegro, it's nice to know what you look like. You on my computer previously showed up as a very, very tiny, undiscernible dot, and lovely to see what you look like.
Well, that looking here looks kind of scary to me.
I'm sorry, could you kindly refer, which, you're talking about,
SB 155, page 3, lines 16 to 20, and starting on line 16, section 4, it says, current and former military service members who have been assigned a military occupational specialty code of 68W, in parentheses Army, or 4N0X1, parentheses Air Force, with or without additional skill and so on. And a constituent brought to my attention that it didn't mention Navy corpsmen.
so this is in reference to the temporary health partners.
Yeah, I see what he's talking about. It lets former military medics be able to use this if they've been doing it within the last 3 years, and it only lists the Air Force and the Army. So what we need is the military occupational specialty number, MOS, or whatever it's called in the Navy, for a Navy corpsman. I wonder if we can just say, but military, without getting into the specific, I mean, because we're going to forget the Coast Guard, and we're going to forget the Marines, and we're going to forget the Space Force.
Representative Roy,
Yes.
sorry to interrupt, but this section should actually be deleted here because we dealt with this in a House bill and we resolved the issue of all the forces and the proper codes. And this section is duplicative. I forget what number it is. I think it's House Bill 145, but I'll get it to you.
Okay.
That particular section is unnecessary and should be deleted. I'll send you a note on the bill that we passed.
Well, that saves us a lot of work. Thank you for interrupting.
Glad to help.
Okay, so
Can
Go
I
ahead.
just clarify what will be deleted?
it looks
This
like
enti-
section 4.
Just paragraph 4 on this, in this section?
Page 3, lines 16 through 19.
Okay,
Well,
I just want to make sure I understand the request. If you're just taking out paragraph 4.
Yeah, let's wait until Representative McGuire sends, if Representative McGuire, if you could send it to Ms. Marlin too, just to make sure the language is, you know what I mean, that it matches up. Is that good? You got that covered, Ms. Marlin?
Well, you know, I'll wait to hear from Representative McGuire. I'm not, you know, confident that that does it. I mean, if it does, that's great. But
Well, we'll just do a side by side and make sure that the issue's covered and taken care of. And if it is, then we'll just delete that paragraph.
I will just add that was an incorrect bill number. I just looked up House Bill 145 and it's a different title and it was killed. So,
Okay, well, that's why we're going to hold off and wait and see what we get.
and the other question is has that House bill that she's referring to passed the Senate?
Yeah. Well, we'll put a pin in that. And if it has been, does everyone agree that we can delete that section if it's been taken care of in another bill that looks like it's going to pass or has passed?
Absolutely.
Sure.
Yes.
Yeah.
All right.
Solidified.
All right. So my section that I had to take care of was the definition. What did a temporary health partner actually mean? And we defined it. If I could find the language Ms. Marlin sent me in this plethora of emails I have. So the definition of a temporary health partner is going to mean the definition will be means a health partner who has been hired under the process authorized according to federal and state waivers. So the concern we had was, what did that mean, temporary health partner? How long would it last? Are we creating a whole new section of employee or LNA, a whole new classification? So I spoke to the people at the nursing, and they don't want this to be necessarily a new alternative way to get your license permanently. This is just for the people who worked under the COVID state of emergency. So the definition therefore applies only to people who were hired under the state of emergency, federal, or because of the nursing homes are regulated by the federal government much more than the state. And they're very particular about waivers and such. So in this bill, for the purposes of this bill, temporary health partner would mean people that were hired under this waiver granted by the federal government and the state because of COVID. Does everyone follow that?
I understand. I would just say I would be supportive of looking at this, not in a way obviously that would hurt anything with federal regulations, but I would still be open to this being something we look at permanently.
I'm glad you said that, because after a conversation with the folks over there, they are very interested in us doing something like that in the fall. So perhaps we could co-sponsor something.
I would love to work with you on that.
Yeah,
Okay.
I agree as well.
Yeah, and I told her, and we talked about it, and the idea of an alternative pathway for people who can't afford the upfront money, because the problem is, to go to the class, you have to come up with the upfront money. You'll get reimbursed, but if you don't have the upfront money, you just can't do it. So
Be a problem. Yep.
yeah, so we can work on it, massage it, and look at it in the fall. So is everyone okay with that definition?
That absolutely.
Representative Grote, you okay?
Can you please just repeat it one more time? There was, I was trying to listen to everything. I sort of lost the original. If you don't mind, please.
No, that's fine. Okay, so we were concerned that there was no definition of what temporary health partner meant.
Correct.
So what it's going to mean is that a temporary health partner means a health partner who has been hired under the process authorized according to federal and state waivers.
Okay.
So very simple. Only people that were hired under this state of emergency and were granted waivers by the state and federal government would be the people eligible to do this.
Okay. Thank you. That's what I thought the final outcome was.
Yeah.
That section then be included in the repeals in the back part of the bill?
Could you repeat that?
Seems logical to do that
What are you asking, Representative?
if it's going to be included in the repeals in the back part of the bill.
Oh, the definition, you mean?
The category, I guess you would say, the section.
Ms. Marlin, are you with us?
I am. I think the idea was that we wouldn't know when the pandemic might end and when this position would not be covered by the federal waiver. It's so tied in with the federal waiver. And so, but when the federal waiver is pulled away, then the authorization for it disappears. So that's the difficulty with identifying a date, unless you try to craft a contingency. But it seemed, the other issue that we talked about yesterday was putting this into session law rather than statute. So it had less of a feeling of permanence.
Yes, that's right. Revise the language so that it amends session law rather than RC 326B. So does that answer your concern, Representative?
Yes, I think that would be appropriate.
Okay, so
also, I do see Representative McGuire's hand up also.
I think Representative McGuire, did you want to speak again? I don't know that it ever got lowered from the first time.
Actually, yes, thank you, Mr. Chair. It's House Bill 567. It would replace lines 20 through 24 on page 3, which is Roman 4 and 5. And I was trying to research the question of Coast Guard and other military codes, because this came up when we were dealing with the House bill. And somehow it was resolved in favor of the language in House Bill 567. However, that is still in the Senate. It has not yet passed. So you could either modify these to the language of House Bill 567, or just delete them, or put in a clause that this section doesn't apply if 567 passes. And I will
like
try.
that.
Anyway, I will try and find the why we didn't worry about the other services. They may have the same codes as Army or Air Force. I don't know exactly. I don't remember exactly what we resolved, but I remember that we did in fact resolve it.
Okay. I like the idea of putting a clause in that says this section shall not apply if 564 you said passes?
567.
567.
567.
I agree that that's the simplest way to resolve that.
Does everyone on the committee, subcommittee agree to do with that? We'll just
Yeah,
add a line to that section. Okay. Ms. Marlin, do you have that?
Sorry, yes, I do. We'll need to just review all this once we get a little firmer in the amendment, but absolutely, I've made a note of it.
Thanks. Okay, so I believe that covers everything that we were going to discuss with this bill. Does anyone have any further comments or questions? All right, let me just, okay. Seeing none, I will go ahead and call the roll. Let me see, are we calling this as amended, or is that how we would do this one?
Where are we going?
We're gonna vote. I'm gonna make a motion, but I need to know if I should call it as amended or because
Yes.
yeah.
It would be amendments discussed in these sections per the subcommittee.
Yeah, okay. All right, I'm gonna make a motion of ought to pass.
Wait, Peter wants to say something. I think we have to do this in committee, not in subcommittee. Is that right?
Well, we have to vote it out of subcommittee.
Yeah.
Go ahead, Peter.
Thank you very much, Mr. Chairman. So I heard you say the bill, and the bill it also, well, it doesn't yet contain the non-germane amendment because that hasn't yet been adopted by the committee. But are you intending to incorporate the non-germane amendment into your motion and in the vote, or is that something that's extraneous at this point?
That's extraneous at this point. The non-germane amendment is actually scheduled for a public hearing next week because it was so non-germane that it was inappropriate to not.
I thank you very much for that clarification. I think that's important, and I had not heard that there was going to be a public hearing, but I fully agree with that. Thank you.
Yeah.
Can I just clarify that there've been more than one non-germane amendments on some bills? Is this the one that's about?
It's about vaccines.
So the vaccine part is going to be a separate amendment now, and is it with the provisions about outdoor dining?
No. The vaccine portion it's going to be its own separate
Hearing.
Yeah, separate hearing.
Right.
But
it has to be amended. It has to be attached to something. It's not the non-germane amendment is not a separate bill. It has to be attached to something. So if it's not attached to this bill, then
well, it's going to be attached. We're going to attach it to this bill, but it's a non-germane amendment. We have to have the public hearing.
No, that's I'm not disagreeing with that aspect at all. But
okay.
Representative Schultz, I think, was unclear as to whether it's going to be attached, and it would have to be attached to this, but it will come after the separate public hearing.
Yeah, that's correct. So what we're doing in subcommittee right now is we're just gonna vote that the changes we made are approved by the subcommittee and refer it to the full committee.
Right.
At which point we're gonna have the public hearing on the non-germane amendment first before we take up the actual whole kit and
Right.
caboodle. Does that make sense?
Right.
Yeah.
That's good process. Yes, I
So why
agree
don't
with that.
we, if we could, just for clarification, when we talk about the motion, to accept these, we're talking about the summer camps, the outdoor dining,
And the
and
definition.
temporary health partners. So let's make sure that in the motion, we mention these three things so that there's no confusion as to what we're voting on. I like
Hunky-dory.
clarity.
Well,
I said hunky-dory, sounds good.
Okay.
wait, now I'm confused again because the
Aha.
amendment I saw wasn't just outdoor dining. It also included the vaccine portions.
No, we didn't discuss that today, Chris.
I'm
We-
not saying we didn't discuss that today. I'm saying the amendment I saw about outdoor dining, page 2, continuing that amendment, was vaccines. So that's why I'm confused.
Yes, Representative Schultz, that was an the non-germane amendment included something on outdoor dining, but the amendment that your subcommittee has worked on about outdoor dining eliminates the need for that portion of the non-germane amendment.
Okay. That makes that a lot easier. And since we're mentioning it briefly, I would say there's possibly portions of the vaccine component that maybe I could support. The longer, newer version obviously is a little more controversial. But anyway, planted that seed. Moving forward.
Yeah, and we'll all have a chance to kick that around at the public hearing next week and see what we can come out with.
Great.
So does everyone on the subcommittee, it doesn't have to be, I guess, an official vote but does everyone approve of the changes that Representative Grote just discussed with specificity to the definition of the healthcare partner, the summer camps, and the outdoor dining?
Yes.
I do.
Representative Grote?
Yes.
Representative Lekis?
Yes.
Excuse me, Representative Lanzara?
Yes.
Very good. Okay. Well, then, without further ado, I will end this subcommittee hearing. I appreciate you guys all coming and enjoy your beautiful weekend. And we'll be back next week.
All right. Thanks. Yep.
Thanks,
Bye-bye.
everybody. Bye.
Bye, everybody.
Efficiency.